Good morning and happy Friday. My name is Kimberly Craig and I'm the President and CEO of the Monterey County Business Council. Monterey County Business Council is a membership-based organization that works together with private business, the public sector, and nonprofit organizations. We're always looking to expand our network, so if you think we're doing good work here, we would love to have you as a member. Our membership applications are online at www.mcbc.biz. We're in our 5th week of continuing our commitment to communication with you. When you registered, you gave us your email address, and we will have more of these free webinars over the next couple of months, and we'll let you know of upcoming discussions on small business opportunities, such as this one. I do want to thank our partners, the Small Business Development Center, the City of Salinas, and the County of Monterey. Additionally, I have to give a shout out to Luis Alvarez of Alvarez Technology Group. The team over there is producing the webinar today. I do want to encourage you to ask as many questions as you want. There's a chat feature on the right side of your screen where you can ask those questions and we'll publish them and do our best to answer every single one. We're also recording this webinar and we'll send you a link with the recording so you can review today's class. We will also send out the contact information for our speakers today. We'll go on to our agenda right now. Our speakers today are Jennifer Mancera, an attorney with Nolan, Hammerly, Etienne & Haas, and Michelle Stanford, a senior consultant with TPO Human Resources Management. They are going over the discussion of navigating employees and the COVID-19 implications. Additionally, at the end of our presentation, we'll take questions, for both Jennifer and Michelle will. And we also have Cindy Merzon, the director of Cal Coastal Small Business Development Center, to answer any questions about SBA loans or concerns there. With that, I would like to introduce Jennifer with Nolan, Hammerly, Etienne & Haas. Welcome. Do we have you on mute?
Yep, on mute. Good morning. Good morning. I'd like to thank everybody that's helped to put this webinar together today and go over the topics for today. Throughout this presentation, both Michelle and I will be working through a number of slides that will include topics such as, is work available, and what does that mean? The different COVID-19 leaves that are available. We will talk about documentation that'll be required to keep in order to qualify for tax credits. We'll touch briefly on disability benefits for self-employed individuals and independent contractors. Additionally, we will talk about the difference between furlough and layoff and how those differences can make changes or implement have impact on WARN Act considerations. We'll talk about the unemployment insurance and the pandemic unemployment insurance, how to prepare for reopening, everything else COVID-19, right, and additional resources that'll be available. So with that, I will jump right into our next slide, which talks about whether or not work is available. Is work available is a question that many employers are likely asking, and what does that mean, right? And so whether or not work is available is going to have a really large impact on what leaves you offer, what benefits are available to your employees, when they can receive unemployment, and as our is leave available slide pops up here, you'll see 3 different boxes, and these boxes can help you understand which buckets of benefits fall into which categories. When work is available, that means that an employee has work hours that are either reduced or unchanged, but the employer actually has work available for the employee. In that situation, employees could be eligible for the new Families First Coronavirus Response Act, emergency paid sick leave, and expanded paid family leave, as well as the California supplemental paid sick leave if you are an employer with over 500 employees. And we definitely don't want to forget that pre-existing benefits are still available to employees. California Paid Sick Leave, the California Family Rights Act, and all of those pre-existing benefits are still available. If work is not available, that means that the employer does not have work for the employee for whatever reason that might be, whether it's a natural decline in the business, whether it's COVID-19 related, whether it's shelter-in-place related. If there's no work available, then the employee may either have been placed on a temporary leave of absence or what we'll discuss later as furloughed. In those situations, the employee would still be eligible for continued health insurance premiums and health insurance coverage offered by the employer. And since they aren't working, they would also be eligible for unemployment with the additional $600 that are offered through CARES. If the employee has been completely laid off and separated from employment, the employee would naturally receive COBRA information from the employer. But other than the employee's election to continue with COBRA coverage, the employee would only be entitled to unemployment benefits, which would range between $40 and $450, plus the additional $600 that would be offered through CARES. And so a lot of what we're going to focus on in this first part of our presentation is the benefits that are available to employees when they are still employed and work is available. And so with that, I'm going to turn the presentation over to Michelle to move on and speak to our next slide, which will discuss emergency paid sick leave under the Family First Coronavirus Response Act. Michelle?
Thank you, Jennifer. Okay, so folks, what we're going to do here is we're going to, as Jennifer mentioned, we're going to first focus on Family First Coronavirus Act, which is a federal relief program for employees and for employers to be providing to those employees. And this pertains to employers who have employees under 500. And so once I've covered through the emergency paid sick leave, then we're going to talk about the expanded paid family leave, and then we're going to switch over to what California is made available as of April 16th. So for the emergency paid sick leave, the effective date is retro to April 1, and it runs through December 31st, 2020. There is no waiting period, and it applies to all employees. Now, this includes employees of private sector employers and certain public sector employers as well. And so that would cover your part-time, your temporary, your seasonal folks. It does exclude contractors who are not employees. And what the benefit provides for is up to 2 weeks of paid sick leave. So for full-time employees, what that means is 80 hours of paid sick leave. For your part-time employees, that means a number of hours that that employee is regularly scheduled to work over a two-week period. So one of the questions you might be asking yourself right now is, well, wait a minute, my part-time employees, certainly with this COVID-19 pandemic, are working irregular hours. Then how do I calculate that? What employers are told to do is then you go back over a period of the last 6 months, you take an average of the hours worked and use that in terms of determining the calculation to pay out their paid sick leave. So this is the benefit that's available as part of the emergency paid sick leave. And let's now go to the next slide to talk about what are the qualifying leave reasons. And so one of the things that's really important to think about, and it touches on what Jennifer first mentioned on the earlier slide in distinguishing between those employees in which there is work available and that employment relationship continues, is that in instances where work is available and employees are unable to work because of one of the following 6 reasons, they are eligible for the federal emergency paid sick leave. Again, this is for employers who have less than 500 employees. So what does that mean exactly? Well, if I'm your employee and I'm subject to a federal state, local quarantine or isolation order related to COVID-19, but and you have work available for me, but I can't do it because of that reason, I'm eligible for the paid sick leave benefit. Or if I've been advised by a healthcare provider to self-quarantine related to COVID-19, or I'm experiencing COVID-19 symptoms and seeking a medical diagnosis, I'm also eligible for paid sick leave. There are also, as you can see here, for the reasons that are important to take note of, is that sometimes an employee may need to care for an individual who's subject to an order that's described in points 1 and 2 above. Or maybe their child's school is still closed, their care provider is closed, and even though there's work available for them, they can't work. Those individuals are also eligible for the paid sick leave benefit. And finally, on the 6th item, if they're experiencing any other substantially similar condition, which is specified by the Department of Health and Human Resources, they're also eligible. And so what's important to understand here is that for those first 3 reasons, when you're talking about the paid sick leave benefit, that includes 100% of their regular rate of pay, capped at $511 per day. Now, if I am eligible for reasons of 4 through 6 above, then I'm eligible to receive 2/3 of my regular rate of pay, capped at $200 per day. So these are the qualifying leave reasons, which also you'll see that some of it overlaps with what California is providing. So let me kind of take you to the next piece of this, and this has to do with the expanded paid family leave. Again, this benefit is for employers with less than 500 employees. It is also effective April 1 through December 31st, 2020. In this particular case, the employees must be employed for at least 30 calendar days. So remember, for the paid sick leave benefit, which is for up to 2 weeks or 80 hours for full-time employees, there's no waiting period. For this particular expanded paid family leave, there is a 30 calendar day waiting period. This does apply to full-time employees. It excludes contractors. And what this does is it adds a new reason for the Family Medical Leave Act, in which it's targeted specifically for caring for a son or a daughter whose school or care is closed or child care provider is unavailable. And the eligibility reason is item 5 for the Families First Coronavirus Act reason that we had just reviewed with you in the previous slide. What this provides for is 2 weeks of unpaid family leave and 10 weeks of paid leave, to a total of 12 weeks. What this means is that for those first 2 weeks, the employees can use the emergency paid sick leave at 2/3 of their regular rate of pay, or if they wish, they can choose to use other accrued leave in place of unpaid leave. The cap for this leave is 2/3, so how this is paid out again is 2/3 of the employee's regular rate. It's capped at $200 per day. And there is an aggregate of $10,000 here, whereas for the paid sick leave under this category, it was $2,000 for a total of $12,000. Okay, that's the federal side. That's what's been made available to employers with employees who have less than 500 employees. Well, what did California do recently? And so let's jump on to that slide next. So what Governor Newsom... Yes.
I'm so sorry, Michelle. This is Jennifer. Before we move on, I'd like to just note a couple of really important pieces that you went over really well. And I think that it's, at least from what I've heard from clients that I've helped, is there's usually a question around, what does this mean with California sick leave? Because we did remind all of our listeners at the beginning of the webinar that we don't want to forget about our California sick leave and these other benefits that are available. And so it's really, really important to note with the expanded and emergency leaves from the Family First Coronavirus Response Act that these are in addition to, not supplementing, but in addition to the previous sick leave that was existing. And we cannot require our employees to use this leave or to use our pre-existing benefits before this leave. So if I have an employee, if I'm an employer and I have an employee that has still existing 3 days of their California sick leave, I cannot require them to use those 3 days before I offer them the new emergency paid sick leave. So it's emergency paid sick leave first. Families, if the expanded paid family leave act, if they qualify it for first, and then any benefits that existed prior to this pandemic. I don't know if you had anything else that you wanted to add there, Michelle, but I think that's a really important distinction or caveat that we want to get out to everybody.
Thank you, Jennifer. Absolutely. It was a great call out. Thank you so much. This is the key item to keep in mind in relation to the benefit provided through the COVID-19 FFCRA. So absolutely. So let me take a deep breath and let's take us to the California side. And so April 16th, this was made into effect. Governor Newsom signed an executive order in which he stated that he took a look at, and there was a concern about in California, what about all of these food service workers? And so what he said is that employers who have more than 500 employees are to also afford them with a supplemental paid sick leave benefit. So this went in effective April 16th. The executive order does not specify a finite end date. What it does say is that it will continue through the duration of any statewide stay-at-home order. Now, for this benefit, there is no waiting period. It applies to full and part-time employees, and it also provides up to 2 weeks of paid sick leave at the same rate and the same form of calculation as you would do for the emergency paid sick leave through the federal program. Jennifer, anything you want me to add on this one before I jump into the qualifying events for this one?
Nope, I think you've covered it all.
Cool, thank you. All right, so let's jump on to what are the qualifying reasons for the California leave. Again, this is for a very targeted group of employees. These are for food service workers, for employers who have more than 500 employees. And again, what's important to remember is tying back similar to the federal leaves that are available, is that this is only available where work is available and employees are unable to work because of these 3 reasons. And what you'll see here, these 3 reasons, is the first 2 overlap what you saw on the federal reasons. The one that's very different here is reason number 3, in which it states that where employees are prohibited from working by the workers hiring entity due to health concerns related to the potential transmission of COVID-19. You'll see here that the form of paid sick leave is the same. It's 100% of regular rate of pay. This is also capped at $511 per day, $5,110 aggregate as the sick leave cap. Jennifer, anything I'm missing on this one that you want to touch on also?
I don't think that there's anything that you're missing. What I would add, Michelle, is that while the benefit does apply to food sector workers, it is only for specific wage orders. And so if you are an employer that is unsure of your specific wage order, I would definitely reach out to your legal counsel or your consultant to ensure that you are operating under the right wage order, because this benefit is not applicable to all wage orders in the state of California.
Excellent, thank you. Okay, so let's talk about tax credits and documentation. this gets a little bit, can get a little bit confusing, but what's important to understand is the available tax credits and documentation only applies to the emergency paid sick leave and the emergency Family Leave Act, only for those two. It does not apply to the California supplemental paid sick leave. And this applies to covered employers who qualify dollar for dollar reimbursement through tax credits. So in order for an employer to obtain these tax credits, what do you need to do? Well, the record keeping requirements states that you want to document who's the name of the employee requesting the leave, the date or dates for which the leave is requested, the reason for the leave, and a statement from the employee that he or she is unable to work due to that reason. Now, there's some other things that could come into play here. So for example, if the employee is subject to a quarantine or an isolation order, or they need to care for another subject to that order, then you would also want to document the government entity name. In addition, if the employee is experiencing COVID-19 symptoms and they are under the advice of their healthcare provider, you would want to document the provider's name. And an important call out here is that very, very important to remember and respect the medical privacy of your employee. So you don't want to ask what their diagnosis is. You don't want to ask specifically about their medical condition, but you do want to get information about that healthcare provider. Who are they, their address, their contact information, so that you have that documented. And then the third bullet here on child care. This is for what the IRS has defined as older than 14 under daylight hours, whose school or place of care is closed. You can also document, you're not required, but I think it's a good idea that you also document the name of the child being cared for, the name of the school that's closed, place of care, child care provider, and then a statement from the employee that no other suitable person is available. And so these are the tax credits that are important for you to be aware of and to follow through on if you fall into these situations. Jennifer, anything to add?
The only thing I would add here, Michelle, is that it's really important that this information be documented in order to qualify for your tax credits. And so employers are definitely going to want to have a single form to document, to use to document all of this information for employees to request the leave, and to keep record acknowledging that the employee requested the leave from you, that it was approved or it was denied for whatever reason, and what the eligibility was for that leave, because without that documentation, you could have difficulties with your credits, and you'll definitely want to consult your CPA or your tax consultant or tax attorney for more advice on the tax credit. But documenting all of the information that you see here on your slide is going to be really important.
Thank you so much. Okay, folks, so we're going to close out on the paid leave benefits by going to one more piece here, and this has to do with disability benefits for self-employed independent contractors. Now, the majority of the information we're sharing with you today has to do with businesses that have employees. For those of you who are self-employed, it's important to call out for you that the Employment Development Department does offer optional disability insurance elective coverage for employers and self-employed individuals that are not required to pay into state disability insurance. So if you are currently covered by them, there's information available for you to research further and obtain in terms of how these benefits are that you're eligible for. If you have not set up one of these programs, EDD does provide additional information on how to get this set up. And at the very end of our presentation, we've included all of the links that help you get direct access, and this is one of them that we are providing. What it does specifically is it covers time off from work to care for a seriously ill child, parent, parent-in-law, grandparent, grandchild, sibling, spouse, or registered domestic partner, or to bond with a new child. And so this benefit is available, and if you have not pursued this previously, definitely encourage you to look into that now. Okay, so where we're moving next is kind of like a deep breath, a pause, and we want to have a slide here that says, what if? So there's some questions that as a TPO consultant, our clients have been asking us, and some of the things that we're asked to help answer for them, we've posed a couple here for you. So we're not going to answer them for you right now. What these are just designed to do is get you to start thinking about what questions you have that are important to you that you'd like for us to be able to answer when we're done with this presentation. And so what I'd like to do now is take us to the next slide, in which Jennifer is going to talk about the difference between furlough or layoff. Jennifer?
Thank you, Michelle. So we just heard Michelle give us a really good rundown of the different benefits that are available for those employees that are still employed. But what about those employees that aren't working? They don't have hours available to them. We may have put them on a temporary leave of absence. We may have called it a furlough. We may have outright laid them off. And what does that mean, right? And in making those decisions in what you're going to do with your employees, you likely assessed your business needs, considered your different options, and factored in your operational obligations. Or if you are in the point right now where you're looking forward, looking at the impact that this pandemic has had on your business and saying, what do I do with my employees? Can I keep them employed? Do I need to lay them off? Maybe I got a loan or I didn't get a loan. Those are all of the different business needs that you're going to want to think about right now. And you're also going to want to think about some of these different obligations that will come into place if you choose to displace some of your employees. And so a really important distinction here is going to be the difference between a furlough and a layoff. And so when you lay off an employee, the employment relationship terminates, right? We've separated either voluntarily or involuntarily. COBRA rights are triggered. Final pay obligations are triggered where any accrued PTO or vacation is paid out, and unemployment insurance notices, among other things, are provided to your employees. If you've temporarily laid off an employee or furloughed them, that employment relationship is continuing. The employee is still receiving health benefits, and if they are in our current situation, if the employee has had their hours reduced, they may qualify for unemployment for that reduction in hours. As we move on to our next slide, which continues to talk about the differences between furlough and layoff, we want to ask the question of, is there really a difference between a furlough and a layoff? And essentially that answer is no. There's not really much of a difference between the two different categories. The difference is very minute, because essentially a furloughed employee remains an active employee, but with just limited or reduced work hours, where, as we just talked about, a laid off employee generally means the complete separation. In the current circumstances, the California Labor Commissioner may not see a real difference between the temporary furloughed employee and the laid off employee. The California Labor Commissioner's opinion has been that if an employer reduces its employees' work schedule hours to 0 and does not reschedule that employee within the same pay period, and I'm gonna call this out a couple of times here, within the same pay period, the employer has effectively laid off the employee, which then triggers these final pay requirements that we just talked about, the COBRA notices, unemployment. And really important is going to be that final pay requirement under Labor Code Section 201. In other words, if an employee is furloughed, involuntarily placed on temporary leave of absence, or laid off without a specific return to work date within that same pay period, the provisions of Labor Code Section 201 do apply. What that means is that at the time of discharge, all wages earned and all wages unpaid are immediately due to the employee, with only very few exceptions for seasonal layoffs within curing, canning, drying of a variety of perishable fruits, vegetables. Essentially, we're talking about seasonal layoff for agriculture employees. Other than those very few exceptions, the Labor Code Section 201 provisions do apply, whether you're calling your separation a furlough or a temporary leave of absence or a layoff. Anything that's going to extend beyond that 1 week period, or if you do your payroll weekly, 2 week period if you do it in bi-monthly or bi-weekly, but whatever that pay period is, if you're extending beyond that point, you're going to have to trigger a lot of these different obligations. And that's why when we're making these decisions, it's really important that we consider these obligations. If we move on to our next slide, we're going to see how the distinction between furlough and layoff and the decisions that we're making come into play with WARN and CalWARN obligations. So the Worker Adjustment and Retraining Notification, better known as WARN, helps ensure advance notice in cases of qualified plant closings and layoffs or mass layoffs. For a lot of employers that are small, don't have over 50 employees, WARN and CalWARN might be a whole new concept. It might be foreign. It might not be something that you're familiar with. And I think it's important to note here that the U.S. Department of Labor has compliance assistance materials available to workers and to employers to understand their rights and their obligations under the provisions of WARN. But in general, WARN requires employers to provide 60 days notice of plant closing or layoff of over 50 employees. And CalWARN is California's counterpart or companion to the federal WARN Act. If we move on to our next slide, we will talk about who needs to be given notice during WARN and CalWARN. Under WARN, there are 3 broad categories of notice. That's 3 broad categories that are going to trigger notice. Shutting down a site, causing job loss for 50 or more employees, laying off 50 employees or over 50 employees or more than 33% of your workforce at a single location, or laying off more than 500 employees at a single location. In California, the CalWARN notices would be triggered for employers with over 75 employees at a single facility when terminating operations, relocating those operations more than 100 miles, or laying off 50 or more employees in a 30-day period. So you were probably asking, well,
I think you're on mute.
She may have lost connection, Kimberly. Michelle, are you still there?
I'm here.
Michelle, do you think you can pick up on some of the discussion on the slide?
Yes, I can. What I'd like to do is give Jennifer a little bit of time to get back on so she can continue through. But until she's doing that, there is a piece to this that I wanted to call out, which we could do right now. And what that is that, folks, when we, Jennifer, would that be you? So when folks are contact us at TPO about instances where they have to face a restructuring or a layoff, Oftentimes, whether or not WARN applies to them or not, one of the questions that they come to us for is, what do I need to document? And what's really important here is having a sound business story. What has changed in your business that's requiring you to either lay off multiple positions, individual positions? What has changed in terms? I'm going to pause here for a moment. Was someone trying to say something? Okay, so what's really important here, yes.
I'm so sorry. I'm not sure how I got disconnected, but I'm back, and I will allow you to continue with your explanation.
Oh, super. Thank you, Jennifer. So I'll finish that up briefly and then turn it back to you to finish up on the WARN, CalWARN. So in terms of documentation, folks, what's really important to do here is step back and think about what's your story. So what has changed in your business? Are you having to reduce, eliminate products or services? Are there individual positions that you no longer are in doing that type of work, so you won't need those? What has changed that you need to make this difficult decision? And you document that down in accordingly. Then your second step is to step back and say, okay, based on how my business has changed, and it might include a change to your organizational structure and functions. What are the positions that are going to be impacted by that? And once you've identified those positions, then the third layer that we talk to our members about is what is going to be your selection criteria, and ensuring that your selection criteria is equitable, it's fair, it's lawful, and it connects directly back to the basis of why you're taking this decision. And so it's really important to think through those before you even get to the point of making a decision of laying off employee or employees. So Jennifer, I'm going to switch it back to you.
Thank you so much for picking up where my call got dropped, Michelle. And I apologize for these technical difficulties to our audience. I guess the technical difficulties that we face are part of the new normal in this pandemic. Not easy to deal with nonetheless, so I appreciate your patience. I believe that we left off, Michelle, correct me if I'm wrong, at slide 16 on who needs to be notified for WARN.
That's it.
Perfect. So I will hop right back into who needs to be notified. We've talked a little bit about what WARN is, what CalWARN is, how you're going to make some of those decisions about laying off your employees. And now you probably at the point in this process where if you are laying off employees, you want to know, who do I need to notify, right? So you need to notify, as you'll see on the next slide, number 16, that all employees who are affected need to be notified, and they need to be notified in the language in which they understand. Whichever their primary language is, that's the language that they will need to receive notification in. And if you are a unionized employer, you will need to notify the collective bargaining agreement representatives if that's applicable to you. You'll also need to notify the chief elected official in your county. If you're operating within city limits, you need to notify the chief elected city official. Notice also needs to go to the local workforce investment board and the EDD state dislocated worker unit. So typically you're going to put together one notice that's going to go out to these multiple people, right? And if you don't put together these notices and you don't notify the appropriate people, failure to comply with WARN and CalWARN could be really costly. It could cost up to 60 days of back pay to your workers on top of civil penalties. And given the financial constraints that many businesses or employers are in right now, that's not something that we want to be facing. So, and you might be thinking, but I heard that, if I'm familiar with WARN, I'm familiar with CalWARN, I heard that those requirements were relaxed. And on our next slide, you'll see that they were relaxed, but relaxed and eliminated are two different things. And so I really want to make a strong distinction here that the WARN and CalWARN requirements are not eliminated, they're not suspended, they've simply been relaxed. And what needs to happen is that these all of these notifications that we just got through talking about still need to be provided. They just don't need to be provided 60 days in advance, because that would have been really difficult to do, given that the situation that we're currently in with this pandemic was not really foreseeable to employers, to businesses, to employees. And so the notice needs to be provided as soon as practicable. So since a lot of employers are right now in this decision of, am I laying off employees? Are they going to be, was this a short-term layoff? Am I going to be bringing them back? Am I not? Right now is a really good time to be making that decision. And it's practicable now to be giving out the notices. These notices must be provided to the employee. And the notices are going to have some specific requirements in them with this relaxed standard. They need to include reference to business circumstances that were not reasonably foreseeable at the time that the notice would have been required, which would have been 60 days prior to their layoff. And they need to inform employees they have specific language actually that's required that you'll see here on your slide, that if you have lost your job or been laid off temporarily, you may be eligible for unemployment insurance. More information on unemployment insurance and other resources available for workers is available at labor.ca.gov/coronavirus2019. That language actually needs to be in this relaxed CalWARN requirement. So when your notice goes out as soon as practicable, you need to have those two things here that you see on your slide, the specific language about unemployment and the language indicating that the reason for the delayed notice or the untimely notice was due to unforeseen business circumstances. And so with that, I will turn the presentation back over to Michelle to talk about unemployment insurance and pandemic unemployment insurance.
Thanks, Jennifer. Okay, so pandemic unemployment insurance, that's exactly what it is. This is beyond the standard unemployment insurance that is available through the Employment Development Department. What this unemployment insurance provides is up to 39 weeks of benefits. The benefit period in California starts February 2nd and it runs through the end, December 26, 2020. This is a new 13-week federal extension. What that means is that it provides for a maximum benefit of 26 weeks. The pandemic unemployment insurance extends an additional $600 to each weekly benefit amount. Now, as the California EDD has defined on their website who qualifies, that includes individuals must be unemployed, partially unemployed, which would include folks whose hours have been reduced, unable to work, or unavailable to work as a result of COVID-19 related reason, and meet one of the following. You are a business owner, you're self-employed, you're an independent contractor or a gig worker, you were qualified for regular unemployment insurance but have exhausted those benefits, and you don't have sufficient work history. This information is provided in much more detail at the EDD Pandemic Unemployment Insurance website, and we provided that link for you at the back of this presentation as well to investigate and research further. So what I want to do is switch from what we've been talking about. Is we first started with focusing on employees who are continuing to work for you, who may be returning to work for you, eligible for the available paid leave. We then talked about situations in which you are either going to need to or have had to make the difficult decision in furloughing or laying off employees. And now we want to switch gears a bit and we want to talk about preparing to reopen. So in this particular, it's kind of like as you're changing your sights now on saying, okay, as we're working through this pandemic and I'm starting to think about my business, whether I'm ready to fully reopen or totally reopen. What do I need to be considering? And so these are some just very high-level tips to help you begin that thought process. The first one, again, is you want to assess your essential functions and create a transition plan. What that means is, what are my most critical and essential functions? Who and what positions do I need to have come back absolutely first in line? What are other positions that I may decide that I don't need right away, but I do eventually will need them, but maybe I'll bring them back in the next 30, 60 days, whatever that time frame is. Whatever that involves, you want to start by creating a transition plan. The second thing is you're building out your plan. It's very important that you stay informed and you're aligned to Governor Newsom's 4-phased plan, because as he begins to reopen parts of California, you want to make sure that your business, as it connects to that, is very much aligned and integrated into what he is setting up and planning to reopen for California. Also, as you're going through this, stay close to the CDC guidelines. And in this presentation at the end, we've included, I believe we've included a link to the CDC guidelines, in which you want to make sure you maintain a healthy work environment. What does that mean? Well, what are the policies and procedures that you're going to put in place for when employees return back to work? In terms of reminding them of safety precautions, COVID-19 precautions and related. And then if relevant, depending upon the size of your business, consider setting up a COVID-19 safety committee. These are going to be your eyes and ears for everything COVID related, to help you ensure you're not only following, but you're reinforcing safe work practices for all employees within your business, as well as for your customers. So as I'm thinking through these quick tips, Jennifer, anything you want to add that I haven't talked about here?
Michelle, I think that you've covered them well. I know that we're going to get into information on training employees and documenting these processes that we're going through. And I will just preface that all of this information that we've talked about today really plays an integral part into this reopening plan, not only from the employment perspective, but from the general liability perspective. As you move on to talk about the sample approach to reopening, Michelle, I think it's going to be important for our listeners to think about the potential claim that they may receive for personal injury or for negligence, just these tort claims in general that could come from their vendors or their patrons or their customers. And following this approach to reopening, training employees, documenting what we're doing, monitoring these systems that you're talking about are really, really important to limit any future liability and to evidence due diligence. That would be helpful in defending any potential claims that may come out of this pandemic.
Thanks, Jennifer. And so that's a great transition to the next slide that gives you a sample approach to reopening. So folks, this is not something that you should feel like you need to do as a prescriptive approach. This was just a brainstorming to say, okay, if a business employer was to start thinking about reopening their business, or maybe they're currently open, but things are changing. And so as California opens and those changes are going to have implications to your business, how should I be responding to that? And so this just breaks it up into 3 different phases. And on the far left side here, we have some things to keep in mind during all phases. So when I said earlier about developing precautions, COVID-19 precautions for when your employees return to work, what does that mean? Well, that would include developing policies that you're going to put into place around social distancing. What does that look like for your business? How is that going to work for your employees, for your customers, in terms of cleaning? What does it mean in terms of business travel, if that relates to your business? Are there common areas? How will you allow employees to have access or not, or customers? And then, as Jennifer was mentioning earlier, really, really important that whatever you establish as your policies, you train your employees. You document it, you train, and you retrain. And then throughout this whole process, you're continuing to monitor your employees for symptoms. And so you see here for each of the 3 phases, you lessen up the amount of monitoring, assessment, evaluating till we all get to the point where we finally say, deep breath, we're done, we've moved forward, and we can resume standard worksite protocols. Or hopefully we aren't in this situation, but if it should happen where it turns out that instances where maybe businesses opened a little too early, what do we do now? It's going back and reevaluating and determining the need for continual policy controls and all that kind of considerations. And so that was the only intent of this slide here. Jennifer, anything you want to touch on with this?
Michelle, I think I will open up a can of worms here and touch on the mandatory masks in Monterey County, the mandatory face coverings. As we go back into starting to open up in trying to get back into some normalcy in what we're doing, we're seeing some changes in the way that we function. Masks are beginning to be required. And I think that is part of this approach to reopening. And so we're definitely going to want to make sure that we train employees on proper use of a mask, making sure that it's covering their face and their nose, that it's a cloth mask depending on the industry that we're operating in, and then it's not a medical grade or surgical mask or traditional PPP unless that is necessary for the medium or high risk industry. But for the general workforce, as the county order has encouraged, homemade or general cloth masks are appropriate. And so I think that's, again, it's really important for our audience to think about and to understand that those masks are required at this point, and that there are resources available that employers can give to their employees so that the employees have an idea of how to make the masks if they want to do them at home. A really uncertain area right now is reimbursement for these masks and whether the employers have to provide them or not. The order does require employers to require their employees to wear masks, which does create a workplace requirement, which could trigger reimbursed business expenses. And I know that this is a whole other category that we could talk about all day long. But we don't exactly know how the general employment law principles would be applied in this situation. But employers may want to consider, if they are not providing the masks, to offer some sort of small reimbursement or monthly stipend for those masks if they are required, and for washing the masks if they are reusable masks. Even that small $5 or $10 incremental cost could save a lot on the back end of a potential claim for unreimbursed business expenses. So I will turn that back over to you, Michelle, with any additional comments on the masks and the new order that came out this week.
Yeah, absolutely. I'm so glad you jumped onto that. So yeah, folks, in fact, there are separate orders that have been documented and posted covering San Benito, Santa Cruz, and Monterey counties. And at TPO, one of the things that we've been providing to our members and clients are regular alerts. We most recently published one, distributed one concerning the new requirements for masks in each of these 3 counties. And certainly, if you'd like to receive one, just kick me an email. Be glad to send you one that gives you more information on this. And it includes links to all the Q&As that touches on what Jennifer was just sharing with you in terms of what is expected of you as an employer, and for employees to follow and make sure that they're also being respectful of. So I think we're ready to transition. Oh, I'm sorry, Jennifer, please.
No, that's no problem. Michelle, I would also just say that our firm is also, Nolan Hammerly is also sending out those informational bulletins. And so I would also make that same offer that anybody who's interested in receiving those informational bulletins on employment law is able to shoot me an email. We can provide some of that similar information with resources to the Department of Labor, Department of Health, and different things that employers can do to try and limit some of the potential liability that could come out of these different orders.
Very cool. Very cool. Okay, so folks, we're getting towards the end of our presentation here, and we're transitioning to our next what if slide. And again, these are questions that are indicative of the type of questions that we're receiving from our members and clients that we're helping them answer and work through. We're not going to answer them at this moment. We're just put them here as a plant. If you have similar or other questions you want to be sure to ask, this is the time for you to stop, pause, think. Be sure to submit your questions through the chat line, so as soon as we're done here, we can dive in and start answering them for you. So lastly, everything else COVID-19. We have covered a wide spectrum of topics for you this morning. Thank you so much for sitting and your patience in listening through all of these topics. They are deep, they're complicated, and it takes a lot of focus to just stay with us. So thank you. So on top of everything else that we've said, what else could there possibly be? Well, first and foremost, required postings. So for all employers who have less than 500 employees, you want to make sure that you have posted in your workplace the poster employee rights, and we've provided the link here. If you have employees who are teleworking, you want to make sure you provide that poster to them via email. For those of you who are eligible, or California COVID-19 supplemental paid sick leave applies to, you also want to provide them with that poster. Again, posted in a visible place in your workplace and provided to anyone who is teleworking as well. Another item to be very mindful of is please don't go lax on your wage and hour law compliance. Make sure that if, for example, if you have any employees in which there has been a reduction in hours, all exempt employees, they must continue to earn $1,040 per week, or $960 per week for employees with 25 or less employees. And for any teleworkers, all wage and hour laws apply. That means overtime, rest, and meal periods. Don't relax on this one. Make sure your employees are still filling out their time cards, their time sheets. They're following those rest and meal period breaks in accordance with the wage and hour laws. And then OSHA has provided information on interim reporting and guidance. Make sure that you are in sync with that. Now, COVID-19, there's still some decisions out there in terms of is COVID-19 a recordable illness or not? It may be. It's still not clear for California. You want to stay in tune to that, and so we provided the link for you there as well. And as always, please don't forget to follow the CDC guidelines. Jennifer, anything else before we start to wind this down?
Yes, Michelle, I think that you did a great job going over that those everything else COVID-19. The one point I want to key in on is the exempt employees. That's always a hot topic, and it's really important to note that if you have any exempt employees that have had their hours reduced or are working less, they of course still need to meet the minimum earnings requirements, but it's essential that their salary is not reduced. So if an exempt employee is working maybe 2.5 days a week instead of 5, their salary should not be reduced unless you give them a prospective pay cut, right? And so you tell them, I'm cutting your salary and I'm notifying you in advance, but don't just reduce their salary because you reduced their hours without giving them new notification of new wages that are going to be due to them. If an exempt employee's salary is reduced, you may very well lose that exempt status for their employee and make them an hourly employee. And so that's a really hot topic. As I said, it's a really difficult topic to manage through. And so I would suggest that anybody on the call that has exempt employees who have had their hours reduced, or the employers are considering reducing their predetermined salary, really reach out to their counsel for assistance with that.
Great close on that one. Thank you so much, Jennifer. Okay, folks, I think we are at the end of our presentation. On our last slide here, we have a long list of employer resource information on COVID-19. This will be made available after our program, our webinar today. And I think we're ready to take a pause and see what questions folks may have. So we'll stand by and hear if there's anything we can respond to.
Yes, Michelle, and as we stand by and wait for some of those questions, I'd just like to remind everybody of the disclaimer from early on in our presentation, and remind everyone again here that this presentation was for educational purposes only, that these seminar materials and this presentation are not intended as legal advice, are not legal advice, nor can the materials substitute for legal advice. Now that you've heard everything that we've presented here, you should contact an experienced employment attorney if you have any questions about your business, your policies, or your particular circumstances. If you don't feel that you have a need for legal services and you typically work with a consultant, I would suggest that you reach out to that consultant who can maybe help you determine whether or not you actually need legal advice. But I do want to make really clear that this presentation was for educational purposes only. And now hopefully we have some questions available to answer.
There's our
Thanks,
legalese. Well, Jennifer and Michelle, thank you very much for a very informative webinar. We do have about 14 questions. I want to be respectful of people's time. It's about 11:03, so if we can maybe get through the questions relatively quickly with relatively quick answers, that would be wonderful. And hopefully we can maybe shoot through these by about 11:15. So I'll go ahead and start the questions. The first question is, as an employer, can you ask for a doctor's note from the employee to use sick leave for quarantine?
Jennifer, you want me to take that one?
Either one, whichever you're comfortable with, or we can
go for it.
Both. Okay, so this is Jennifer. My response would be that generally we do not ask employees for doctor's notes. If the employee is requesting to use the Families First Coronavirus Response Act emergency paid sick leave, and they are seeking a diagnosis, or have been quarantined, that act itself does have some provisions for asking for doctor's notes. We don't want to ask for specific information. But in this instance, I would say if they are asking to use those benefits, those new benefits, you can ask them for a doctor's note. Michelle, do you have any thoughts on that?
I would just add to that to be mindful of California's paid sick leave benefit, to where until they've exhausted those 3 days of paid sick leave, an employer would not be allowed to ask for a doctor's note from the employee. So it's a difficult and challenging balancing act. And again, if you're in doubt, certainly I would call on an HR consultant, and TPO is certainly available to help you with that too.
Excellent. Thank you very much, ladies. Next question. A business is closed due to the shelter-in-place orders. The owner decides to pay the 4 employees wages even though they are not working. Can these paid wages qualify for the sick leave tax credit for the employer?
This is Jennifer again. My answer is no. So at the very beginning of the presentation, we talked about whether or not work is available, and what benefits are available if work is available or not available. And so if work is available and the business is open, the business would be able to claim credits for those wages. If the business is closed because of the shelter-in-place order, that means that work is not available and those employees, unfortunately, are not eligible for benefits. There may be other tax credits, or, I know this is definitely not a presentation on the CARES Act, but there may be other avenues available to receive help with payment of those wages, but the Families First Coronavirus Response Act would not be the resource that you would use to cover those wages. Michelle?
Yeah, absolutely. That's what was definitely my answer as well. The answer is no. One thing I would call out is kudos to the business who's doing that. My goodness, that you continue to pay your employees even though they were not working. What a wonderful gesture to those folks. The only other thing I would add, and I know we don't have time to get into it today, is that if a business has applied for the payroll protection program, that program provides a loan, forgivable loan, but that requires an employer or business to keep employees on payroll through the end of June. In that instance, there may be some benefits as part of loan forgiveness by continuing to pay employees, but it's very specific to the PPP program.
Yeah. Excellent. I was just going to check in with Cindy Merzon with the Small Business Development Center, and she's nodding her head. So I think we're good on that. Anything further, Cindy?
Nope. Great job, Michelle. That was exactly what I was going to point out. The Paycheck Protection Program would help that employer who's continuing to pay employees.
Excellent. Okay, well, we'll move on to the next question then. For FMLA extended leave, does the employer have to pay this cost up to 12 weeks? Also, what if the employee has to care for their child part-time and work part-time?
That's a great question. And so there are some distinctions. When offering this new FMLA expanded leave, we need to make sure that the employee actually has leave available to them. This new leave is part of FMLA as a whole. And so if your employee has used up 12 weeks of their FMLA already, unfortunately, they wouldn't be eligible for the expanded leave. They're eligible. The expanded leave is available for up to 12 weeks, but that 12 weeks is going to be limited by what the employee may have already used. So I think that's a really important caveat to make sure that we're aware of. The employer does need to pay that money to the employee, and then could recoup that money through the tax credit, their quarterly tax filings, and they would definitely want to reach out to their accountant or their CPA for information around that. And if the employee is caring for a child whose place of care or school is closed and they need to use that leave intermittently, that's going to be a decision that's up to the employer. The law or the bill as it's written and the regulations as they're written do not require intermittent leave be provided, but they don't prohibit it either. So that would be an individual business decision. Do you have anything else to add there, Michelle?
No, thank you. Great, well said.
All right, well then we'll move on to the next question. If an employee has COVID symptoms and is told to seek medical attention, how much time should an employer wait? What do you do if the employee doesn't go to the doctor? Can you tell him to stay home for 2 weeks but not be covered under the PSL CARES Act? Cindy?
That's another great question. Michelle, do you want to tackle that or shall I take it?
Actually, I was going to ask for the question to be repeated. So if you're good, go for it.
No, go ahead. Let's go ahead and repeat the question.
Sure. The question is, if an employee has COVID symptoms and is told to seek medical attention, how much time should an employer wait? What do you do if the employee doesn't go to the doctor? Can you tell him to stay home for 2 weeks but not be covered under the PSL CARES Act?
My take on this one, if the employee is experiencing COVID-19 symptoms and they are seeking out medical care, that falls within, I believe it's number 3, or it's possibly number 2 of the 6 qualifying reasons. I would afford them whatever is reasonable for that employee to obtain medical care. So, and that's difficult right now, right? Because you have so many of these healthcare providers who are stretched to their limits right now, and being able to get time is difficult. So I would work directly with that employee to say, hey, what do you think is a reasonable amount of time in which you're going to be able to check in and meet with your healthcare provider, and work that through accordingly. I would think that, again, there's no prescripted time frame. I would just work it through with that employee. And in my mind, if they need up to a week, that in these circumstances, that would seem reasonable to me. But Jennifer, do you see it different?
No, I agree with what you said. I think, though, that one of the things that an employer in this situation could do is not forget that standard FMLA and CFRA are available. And so if you have an employee that is not wanting to go to the doctor or not wanting to come back to work and chooses to stay home, I think that it's really important that we revert to our standard forms of documenting an employee's leave from work, and we give them that specified time frame to provide us some sort of medical certification. We're not asking for specific information about why they're out of work or why they're away from work, but we are asking for some sort of medical documentation that will permit them the time reasonable or needed to be away from work. Now, I would agree that we need to be a little bit flexible with those time requirements, given that many medical facilities are just really burdened at the moment.
Great. Thank you for the comprehensive answer, ladies. Appreciate that. Next question. For the EPSL, is that paid by the employer?
Yes.
That is paid by the employer. It's paid by the employer at the time that the employee requests it. The employer can request a tax credit when they file their either 941 or 943 filings, quarterly filings.
Great.
Thank you for the very direct answer. That was a yes or no question.
and to jump on that, and I'm sorry, to jump on that, the IRS has some great information on their website that specifically speaks to how all of that works.
All right, thank you. So the next question is, is the shelter in place or stay at home orders affecting all of California? Is that considered an isolation order?
It is considered an isolation order, but in order for the employees to qualify for benefits under that, there has to be work available where the employee cannot work because of the isolation order. So if the employer is open and they're considered an essential employee or employer, and their employees would thus be considered essential employees, and those employees can't come to work because of the order, they might be qualified, but at least thus far, we've been hard pressed to find situations where essential employees would qualify under the isolation order, given that they're exempt as essential employees.
Got it.
And if they're not essential employees, they're likely working for a business that's closed.
Okay, thank you. Next question. Are part-time employees not eligible for EFMLA?
Correct. The emergency paid family leave is available to full-time employees.
Okay, great. Next question. For the supplemental paid sick leave for food sector workers, does this include grocery stores or grocery store workers?
The way
So
that this
that-
is, oh, sorry.
Go ahead.
Jennifer.
No, go ahead, Michelle. Go ahead.
The way that it is defined in the executive order is anyone who is involved in the preparation, production, distribution of food would be covered under this particular executive order. Jennifer, please build on that.
Yes, so there are a limited number of wage orders that are applicable to that, the governor's executive order, 8, 14, 13. I would have to pull out the order and check exactly which wage orders they are, but a grocery store worker, a grocery store chain may have workers under multiple wage orders depending on what the employee is doing. And so there, it's going to be really important for that employer to reach out to council if they don't know which wage order their employee is working under, because only a limited number of wage orders are applicable to that order.
Okay, thank you. Next question. I think we have about 4 or 5 left, so we'll try to move through these as it's 11:15. Do employers get a tax credit through California or federal funding for, do employers get a tax credit if an employee has to care for a child part-time for children over 14 only? And where would I find that in writing? Thank you.
Would you mind repeating that question, please?
Sure. Do employers get a tax credit if an employee has to care for a child part-time if the child is over 14? And where would I find that in writing?
So my understanding is that there are very limited exceptions to caring for children over the age of 14, and the employer, again, should reach out for advice on those situations. It's going to be a little bit difficult for the employer to gather that information, because you may then be asking the employee for medical information about their child, and so it can be a really difficult situation to navigate through. And I would suggest that the employer seek assistance. Michelle?
Understood. Oh, go on.
I would agree. There is some information out on the IRS site concerning documentation for claiming the child care. However, I echo what Jennifer is saying as well.
Great. Thank you, ladies. Next question, and this one has been a topical debate. When we go back to work, what are employer rights to check employees, i.e. checking temperatures at the door, etc.?
Be very careful. So temperature checks are allowed. And this is another TPO alert that we had recently put out, in which we offered a couple of different options. One is less is a lighter touch, and one is a stronger touch. And the first one is if you are going to do temperatures, the first thing is post notices in your workplace in terms of the importance of COVID-19 safety precautions, give them reminders throughout the day, and then consider providing the employees with a thermometer to take their own temperature in their cars. So that's a softer approach. If an employer feels like that they need to take a stronger approach based on the nature of their business, their interaction with other employees and customers, then the recommendation is you need to give employees appropriate notice. What that time frame is, 2 weeks is as much notice as you can give them. You need to determine who is going to be doing this? Who's going to be qualified to conduct the temperature checks? And also, you want to make sure that you're preserving privacy. So privacy of the individuals, the employees whose temperature is being taken, and that you're capturing the data in a confidential manner, and in that you're keeping it separate from the standard personnel file. Jennifer, what would you say differently?
I would concur with what you said. It's a very difficult situation, and I know there's a lot of information that's out there on it. You know, the EEOC has provided some guidance. That doesn't necessarily mean California is going to follow that guidance. And so I would approach it very carefully, and I would approach it from, as you said, Michelle, allowing the employee to do some of those things themselves, which might shift some of that liability off of the employer.
Excellent. Thank you, ladies. Appreciate it. Next question. If an employee elects to stay home due to the fear of COVID-19 and we are an essential business, would that be considered quitting? If this employee then wants to restart working when others have taken their workload, what would we do? EDD is sending us forms as if we reduced their hours.
So if I understood the question right, that's an employee that has work available, but that is refusing to work.
Correct.
Difficult situation. That's going to be up to the employer, in my opinion. Michelle, I think you may have some thoughts on this as well. But unfortunately, it's going to be, you know, work is available and the employee is refusing work. I would say if the employer has a discretionary leave policy, that's an unprotected leave policy, they may offer that to the employee. But in that situation, there aren't many protected benefits that are available to the employee. Michelle?
Yeah, this is, as Jennifer said, it's a really tricky and difficult situation. And we get this question that comes up quite frequently with our members and clients. And what we say to these folks is that, hey, sit down first and have a conversation with the person. Why are they refusing? There could be a whole host of reasons. So for example, am I afraid to come back because I'm afraid of exposure to COVID-19? Am I possibly a high risk person? So am I in a particular category that puts me at a higher level of risk than others? And so try to understand the basis for why they are saying they are either refusing or don't want to come into work. On the far end of it, yeah, I mean, is the person saying they are resigning? But before you even get there, try to understand what's going on with a person to help understand, you know, what's going on with them and how you can work with them through that situation before you make any decisions about their availability or not willingness or not to come back to work.
All right, thank you. This is a nonprofit business question. Our nonprofit business with fewer than 12 employees had to close due to the pandemic, and as a result, temporarily laid off all employees. These layoffs happened before many of these new COVID-19 rules were announced. Because these layoffs have continued past one pay period, are we required to pay out all accrued vacation time immediately, even though we plan to bring everyone back? Due to the nature of our business, we cannot resume programs because of the mandated health restrictions, and therefore we will not have work for our employees until restrictions are lifted. Paying out all accrued vacation pay will be a major hardship because of the circumstances. We are in a tight spot and would love some guidance.
Yeah, that's a really difficult situation, and I would definitely suggest that this nonprofit seek counsel, because unfortunately, WARN notices, the relaxed WARN notices, it sounds like, given the limited information that's been asked or provided in that question, sounds like the WARN notices need to go out and formal separation needs to occur if they've been closed for this long and there is no specified return to work date, which would mean that all of those Labor Code Section 201 provisions apply. Wages need to be paid, and that's going to include any accrued vacation or PTO that's on the books.
Okay. I think this next question is similar to one that you've previously answered, but I'm going to go ahead and ask it anyway, just as we're trying to get through everyone's questions. I have a couple of employees that are afraid to return to work. We are a hotel that was provided with the PPP loan, and there are tasks and projects that can occur, but they do not want to return. Do I have the capability of laying them off?
Yeah, a layoff is at the employer's discretion. They can choose to lay them off, and as we just discussed, pay out those benefits, or they can choose to have acknowledged that or accepted what would otherwise be an employee resignation if they're refusing to come to work. Again, real hard spot to be in. I mean, you have these employee morale issues. You have ethical considerations that each business will approach differently. So that's going to be up to the employer what they do with an employee that doesn't want to come to work.
All right.
Yeah, another piece that worries me about that one is that if the employee, the food service worker, they're refusing to come back without going through an interactive process of understanding what the concern is of the employee, I would be fearful if there was a situation in which the employee may be eligible under the ADA, Americans with Disabilities Act. So I'd want to make fully certain and understand, why is the employee afraid? Are they afraid because they don't have confidence in the employer that when they come back, they're going to put all the safety precautions in place? And so maybe one of the ways to address that once you're talking to the employee is to say, hey, this is well thought out. These are the steps in which we're going to protect our employees and our customers to ensure as best as we can their safety in returning back to the job. It may be where that alone is enough to change their mind. Who knows? But I would still go through that process first to understand from them, why are they afraid? Why are they declining? Why are they refusing?
Okay.
Yeah, I would concur with that. I think that the interactive process is always a good spot to go to. I would just suggest that it's approached very carefully, because if the employee has medical concerns, or they would qualify for ADA, you want the employee to provide that information and not for the employer to be eliciting it from the employee.
All right. Thank you, ladies. I think we have a couple more questions, but they've been repeated. So I'm going to skip to the very last question, and then we will wrap up our presentation. Last question is, as businesses open, there are new restrictions such as the child care and summer camps, wherein teachers must be stable and students. What happens to mandated break times and lunch times and overtime for full day programs?
Sounds like this is a summer program or a child care provider.
Yes.
Yes, there are specific qualifications for those programs to continue to operate with, specific number of children to the same provider. And unfortunately, labor code regulations have not changed. You still have your standard wage and hour rules that need to be complied with. And so there, the business is going to have to really consider their operational obligations and their needs, and figure out a way to kind of stagger things so that they can comply with all of these different mandates.
All right. Thank you. I appreciate it. Go on.
Before we wrap up, I'd just like to go back. I believe I heard a question earlier asking about emergency paid family leave, if I'm not mistaken, for part-time employees.
That's correct.
Yeah, and so I want to just make a correction to the answer that we provided. Part-time employees are eligible for that leave, and their day is measured by the average number of hours worked over the prior 6 months. And so it's not an easy calculation that might be done, but those employees are eligible for the leave.
Okay, thank you for the clarification on that. I think
You're
that
welcome.
concludes our question and answer period. Just wanted to thank our partners, the Small Business Development Center, the City of Salinas, and the County of Monterey, and also our speakers, Jennifer Mancera, our attorney with Noland, Hammerly, Etienne, and Haas, and Michelle Stanford, Senior Consultant with TPO Human Resources Management. Thank you very much for being on the call today, ladies. And just a reminder to our audience, we are recording this webinar and we will send you a link with the recording so you can review today's class. We'll also send out the contact information for our speakers today. I recognize that there's a lot going on in the world and we really appreciate the time and everything that you've given to us today, and we hope that you learn